No? He has joined. Dr. Fernando. Okay, we'll move on to next one. I'll confirm him later. Madam Professor Anuradha Maheshwari. Next speaker. She is going to speak on reimagining intellectual property rights in digital era. Madam, you have 10 minutes at your disposal. Please, I welcome you. Thank you.
Thank you for this opportunity. Good evening to the chair, co-chair, and esteemed colleagues in this August gathering. So today I am here to speak to you about AI, which is a vast ocean in itself, and about law, which is another bigger ocean than AI. And in that, I'm going to take a very, very narrow and a very focused subject, and that is about AI and the conflict with copyright law only. This has been my limited submission over here, and I hope to finish it within 10 minutes. So let's see how it goes. And for that reason, I have not done a PowerPoint presentation because I want to keep it concise. So I want to begin by giving a very bizarre example that happened a few days ago. And that was a news item which said a lady in Bristol, UK, she ended up marrying the River Avon. She actually married the River Avon 3 years ago. And now, after some 3 years, she has moved the British government to give personalhood to the River Avon. I hope we all understand what it means. She is asking for the river to be recognized as a person. Now, my question is it all that bizarre? Is it so absurd? And to my mind, I did not find it that absurd, considering the history of events, inventions, revolutions that have shaped mankind. So for every invention that came, man questioned it, man was threatened by it, and today we are facing that same kind of issue with the advent of AI. But if I am looking all around me, I know that AI is here to rule the world. AI is going to be for me like water, electricity, everything. My life is going to depend on AI. Perhaps we are doing it a little less in India, but it is simply amazing. As a lawyer, I see every day, people, when I ask them, do you have something like an agreement between the parties? And they send me agreement drafts. And for a few minutes, we are completely confused because it looks like a real agreement till you read it carefully and you realize that this is ChatGPT. So this is the constant situations we are faced with. But nonetheless, it set me thinking. And I said that this giving personhood to river is an important discourse in my discussion for trying to push legal boundaries as it exists today to be able to encompass and incorporate the revolution of AI. Because currently the laws that we are having are absolutely inadequate to deal with AI. So there is AI, there are those inventions. Now, when we are talking about AI, there are multitudes of inventions in different areas of, application that for which we have different laws in place. So while you are talking about privacy violation through AI, we could also be talking about your, cyber crimes, which is in a different area and body of law. And what I am dealing with is another fantastic imagination of man. So I keep asking personality for rivers, how different it is for what we all have done in today's world, and we are being ruled by it, and that is companies. If you look at a company does not exist in tangible form. It exists only in the eyes of the law. So it is an intangible person, an artificial legal entity. Similarly, we have the case of Saudi Arabia, where Saudi Arabia gave citizenship to a robot, called Sophie. And this was in 2019, if I am not wrong. This robot was created by Hanson Robotics from Hong Kong. Now, to give citizenship, that means I am imagining something more than already exists in the citizenship law. So we are reconfiguring the citizenship law to accommodate Sophie. So this is my premise. We are having companies, we are having robots. So why cannot we do something to relook and reshape AI tools? Now, where did this question begin in my mind? The question began with the multitude of cases that we are seeing today. Huge multi-billion-dollar cases being filed against AI company, whether it is Sam Altman's OpenAI, whether it is what Upendra Bakshiji mentioned about Anthropic. Anthropic has come out with a revolutionary AI, which is Claude. And the Claude is able to give you brilliant answers depending on how you prompt it. But Claude could also be wrong. So now when this happened, when Claude was out in the market, a group of musicians, Concord Music and other musicians, they joined, as well as a group of authors joined to file a $3 billion suit against Claude, saying that Claude has infringed our copyright, including Elton John's copyright, including all the famous people, because all these AI tools are scraping the public domain to extract data. Now, once they extract the data, that is where my problem arises. As many people who are coming from the world of AI and technology would tell you, AI is not copying and putting it out there. AI takes the technology, AI assimilates, integrates, decomposes, then breaks it up into what is perhaps called as tokens, and then re-assimilates them to put it out in a different form. Now, the problem is here that different form is the AI version. The different form is not being manipulated by a human being. It is, in a way, being manipulated by the prompts, and in a way being manipulated by the training data. So the training data that has gone, huge loads of it. So when a song comes out, how can I say that this is the song, Elton John's song, or this is Stephen King's song, or whatever? I cannot say that. So it's, I will just give a recent case that happened in India with A.R. Rahman. A.R. Rahman has been charged with infringing the famous Dagger brother composition. So when Justice Pratibha Singh, brilliant judge, she heard it, her verdict was very interesting. She said that it appears, no, not only that, it is in fact identical copy of the Dagger brother composition. So there's an interesting thing. She says it appears, and then she says it is in fact. So this tells you that when you are identifying a copy, then it is your subjective opinion. Whether or not it is a copy, unless and until we are doing technical mapping, we will not be able to say this is a copy. You may say, he may say something else, she may say something else, because it is subjective. I may feel it's a copy. So these are some of the questions for which we don't have answers. But there are cases where the US courts have given contrary views. So that's what led me that we really need to look at the copyright laws all over the world, not only in India, but I can tell you about the Indian copyright law, where we say very clearly that for infringement under Section 51 to take place, there should be unauthorized use. Now, that is happening uniformly across all AI tools. They are unauthorizedly scraping data, taking it and using it for themselves. But how much of that data is getting put out there? How much of that data is being reproduced, as we say in copyright language? How much of that data is being replicated? We do not know exactly. Question number 3, Are all the data that is generated by the AI, is it actually being used to commercialize? Not sure again. So there are a lot of answers which are not there, but yet people are filing these huge volume of, what we call as infringement suits. Now, if you would have all noticed, I have deliberately kept out infringement in the area of trademarks, infringement in the area of artistic works, infringement in the area of patents. Now, patents is one area where Claude is helping tremendously. So it helps you to write your patents where patent drafting is very, very difficult. So when all this is being looked at totally, our question is whether training AI system on copyrighted material itself constitutes reproduction, which I don't think so. That is what I need to examine under different categories of intellectual properties: text, music, photograph, images, all of that, they are all different. So even in the New York Times versus OpenAI case, Microsoft versus Authors Guild case, in all these cases, the judges could not determine copyright infringement. However, in an Getty Images versus Stability AI, the judges were able to conclude that the reproduced images were a copy of the Getty Images. So this sort of differs from the AI output differs from case to case basis. So with this, I would like to go back to the very important case that we had, the landmark case in India of R.G. Anand versus Deluxe Films, in which they say that, the copy must be so close to the original that it should give you the feeling that you are seeing or viewing the original. Until that happens, we cannot say that there is copyright infringement. If this is the parameter, then perhaps this needs to be changed, because we'll have to look at other parameters of the AI. So my submission is very simple, that even if one establishes factual copying of text in the data scraped from public domain, as is alleged, it is difficult to prove exact reproduction of the copyrighted material or the substantial similarity in the work. So whether it is AI or agenting AI, can it be held guilty of infringement? So see, when we pin liability on anybody or anything, first thing is hands off, I'm not liable. So if you're saying OpenAI is liable, OpenAI is saying we are not liable, the AI did it on its own. So then who is liable? Then comes another thing. If you are coming out with a brilliant AI, then who is going to get the profits of commercializing that AI? Then OpenAI will say, I own the AI. So the AI is mine. So you see, this is the confusion that is happening. So this is where I think that maybe we need to give a personhood status to either the AI or the agentic AI, or make it very clear that any company producing the AIs will alone reap the benefit of the AI and will therefore also be equally liable for whatever the AI does that is not correct. So with this, I am going to look into doctrinal evidence and research to find out more about whatever I can find, because I find this topic interesting and purely, and at this age I don't need to do research, but I think I should do for pure pleasure. So with this, I'll end my session. Thank you so much. Yeah.
Thanks, ma'am. I just want to supplement it. We have to think whether we are writing for the AI or AI is writing for us. That is the main thing, because she said for commercialization, all these companies, they are using our data. They have infringed data with them, and they generate data for us. But firstly, we have generated the data, then only they are giving us the data. Wrong information, right information, that is separate question. But we have to see who is generating data. Is it us or it is AI?
Who is accountable, basically?
But there is also one case, where in the name of Raghav, the artificial intelligence, in the name of Raghav, artificial intelligence, they tried to go for the copyright of the material. But ultimately, the Copyright Act of 1951, they have raised an objection that AI is not, Raghav is not a person.
Ignorance. So when Ankit Sahani, the artist,
True.
he invented Raghav and he copied Van Gogh's painting. So when he did that and he said, I will first take copyright in the name of Raghav.
Yeah.
So then he said, somebody must have corrected him. Then he said, I will take copyright in the name of Raghav and myself.
Yeah, in the joint name.
For the first time, the Copyright Board of India granted Raghav the copyright. Then when this was examined and the Copyright Board was asked, how could you grant it to a non-human entity?
Yeah, they have interpreted the definition of a person. Yeah.
Personhood thing comes, should they own the AI?
Yeah.
Just to add it over there. See, ma'am, here we say, in the law we say that once it personifies any corporate, then only it has rights and duties, then only it is separate entity.
Correct.
To do this, all they need to do is personify AI.
That's what I'm saying.
That's it.
That's
Apart from that, there is nothing else which.
absolutely. It's no, I don't think it's.
If it is not personified, it will remain as a property, and property is always with the company.
But then there is a flip side to it. No? At the end of the day, how do we make a machine accountable?
Because it is a product. Technology ultimately it is a product.
See, I'll give you the parallel with company. When companies, AI is responsible for crimes. So when company is guilty of any crime, the people who are getting punished are its directors, its managers, etc. Company itself is not getting punished, it can be fined.
Yes.
That is the extent of the penalty. So all these considerations, see right now I don't know what's the wrong and right answer.
No,
I'm just trying
But
to
it's really thought-provoking, topic. It's really very interesting. Very interesting. Thank you. Thank you.
Thank you, madam. Thank you so much. We have next